Okay, so here's the thing. These are the items that could sometimes mean a good thing post-hearing, right? So you had your disability hearing, you were in front of the administrative law judge, you did your spiel, right? I told the judge what I thought, I told him what was on my mind, I answered the questions, I went through the hearing, and then boom, now we're in post-hearing. These are the things post-hearing before you get a decision, right? Unfavorable, partially favorable, or fully favorable for Social Security disability insurance or supplemental security income. These are the things post-hearing that essentially could potentially be negative items for your claim. They could foreshadow, they could be the great ring that should have fallen into the mountain of negatives that could be for your disability claim, whether it turns a fully favorable into a partially favorable or a partially favorable into an unfavorable, or if it was just going to be an unfavorable to begin with. Let's get into it. All right. Now, also, please remember to hit the smash button. Please don't be stingy with your likes. They're super important to the success of this channel and the world in general. Just kidding. Nobody would really think this channel is that big. But anyway, the point is, please hit the like button. Okay. Use your clicker. Use your clicker. All right. Here we go. Now, number one, the disability judge requests additional CEMEs. If your disability attorney did not request from the judge additional CEMEs, which are consultative examination medical experts, where you go see their doctor, and the judge is requesting them post-hearing, that's not always a good sign. That's not always a good sign. Very rarely it can be, but that's not always a good sign. Number two, the disability judge requests vocational expert interrogatories. Almost always a bad sign. Almost always a bad sign, where the judge will send out interrogatories, a piece of paper with questions on it, to a vocational expert to give testimony as to what your capabilities are when it comes to work. Almost always a bad sign post-hearing. Number three, the disability judge withdraws the negotiations related to the alleged onset date. Now, let me explain what happens with that one. Let me just go a little bit into that one. Okay, what happens is the disability judge, through their clerk, will reach out and say, we like this alleged onset date. What do you think? And then the attorney will be like, I like this one. Or, yeah, I agree. That's a good one, right? And then if you're like, okay, cool, let me go check with the claimant. And then you call back and they've withdrawn that alleged onset date because they found something in the record, whether it's drug abuse or something might be fraudulent, and they withdraw that. That's a problem. That's an issue. Next one. The disability judge is taking more than 7 months to decide your claim. So sometimes claims take longer. Sometimes judges get busy. Sometimes judges get sick. Sometimes judges, just life happens. They have families. I don't, but that's what happens, right? So they have kids. I don't. That's, life is what it is, right? They go to Olive Garden more than I do. The point is, okay, I don't know why I said Olive Garden. I just feel like that's where families go to celebrate. They go to the Garden of Olives. But anyway, the point is, okay, the disability judge, sorry, my dog is snoring. The disability judge, oh man, she is really snoring. I don't know if I had a microphone faced that way, you would be hearing this chubby dog just take the air. She just takes it from the room. Anyways, point is, as I'm literally giving this video, she's 10 feet that way. Anyway, the point is, disability judges, when they take more than 7 months to decide your claim, what happens is we're starting to get into that dicey territory. They might be busy. They might not like the claim. There might be some problems. They might have to have them fixed. So that's not always a good sign. Next one. The disability judge is requesting that OIG utilize a CDR unit to investigate something. Always a bad situation. That ain't never a good situation. There's literally, even as I don't know why I'm so shiny. Oh, it's because I've started to use lotion on my face, by the way. So I'm going to be shiny from now on. Anyway, the point is, because I was graying and looking, ugly and all that stuff. And I was like, what is going on? Why am I an insomniac that also shows the signs of insomnia? Anyway, the point is, if they're utilizing OIG to go ahead and get a CDR to investigate your booty, then that's a bad sign. Very bad sign. Never a good sign. Next one. The disability judge is obtaining medical consultative opinions 4 months after the hearing. Never a good sign. That means the judge was looking for something. The writer might have heads up them on something. It's gotten 4 months down the line. They're kind of behind for whatever reason on your particular claim. And now they're seeking medical opinions to get further clarification on a particular thing. Not usually a good sign. I mean, there's a 1% chance they're just trying to clarify something to validate a bullet point and then pass it through as a fully favorable or partially favorable. Maybe, but 99% of the time, that's not a good thing. Okay. Next thing, the disability judge is requesting additional information on whether the claimant has had corrective surgery, and if so, what their current medical condition is. Never a good sign. If you're getting corrective medical surgery, they want to know months after it how well you've kind of like gotten better. And now shadow snoring. And so that's one of those things where they're looking to see, okay, can I design this person because they did the corrective surgery and now they're doing better? Next one. The disability judge is requesting the attorney to brief a subsequent issue related to evidence not originally converted from the case documents folder into the exhibits folder. Never a good sign. If they're relying on something that wasn't in the exhibit folder and then months later they're like going to the case documents folder and being like, oh, what's this? All right, attorney, go figure this out and let me know. Not a good sign. Because if you have to rely on something that was so unimportant before, you hear that? The snoring, the level of snoring. During my video, I was insulted. You hear it? Wait for it. Just wait for it. It's like a dolphin coming up. Just wait. Can you hear it? It's back there. Anyway, point is, if a disability judge is doing that, okay, I'm just hearing snoring. I have two chubby dogs are snoring. They had steak today because I don't eat the steak. They literally eat the steak. I specially cook it so that's overcooked so I get all the fat out. It's terrible for me because it's like an orchestra of chubby dogs just snoring in the background. Anyways, the point is, disability judge is requesting that the attorney clarify something like that. That's not a good sign. Because if the claim is having to rely on something that didn't even make it into the exhibits folder, and it's in the case documents folder, and nobody was really giving enough attention to it, and they're like, it's over there, that's not a good sign. Next one. The disability judge sends out a medical questionnaire to your physician that seeks clarification on 1, medication usage or abuse, 2, statements as to current condition, 3, clarification on information present in the record. Almost never a good sign. Because if they're reaching out to somebody to clarify something, which is really what they're doing, because if you've already seen a doctor and they're reaching back out to that doctor to clarify something they've said previously, almost never a good sign. Next one, a subpoena to someone, really anyone, for anything that results in a second hearing. Almost never a good sign. Because look, if they have to bring somebody in to clarify something or get a specific thing of testimony from that individual, a lot of reliance is going on that. That's usually to go ahead and deny the claim. Next one, a request that the attorney withdraw from the claim from the judge. Never a good sign. Never a good sign. The judge recuses themselves from the claim. Not almost never a good sign, unless it's like, there was something that happened during the hearing and maybe there's potential bias there now, then it's okay. But otherwise, that's not usually a good sign. A new judge is assigned and a new hearing is requested. Not usually a good sign unless the prior judge was super duper bad or hostile towards the claimant. Then it could be a good sign. The chief ALJ takes over the claim without explanation. This has happened to me, many times over the course of all the years that I've been doing this, but it's always an extreme rarity when it happens because it's odd. If you're like, okay, I'm working with this disability judge, here we go, we do the hearing, and then all of a sudden the chief ALJ of that particular, geography-based hearing office takes over the claim, that's never usually a good sign. The chief ALJs tend to be a little less liberal than the traditional ALJs, although it goes both ways. It really does go both ways. They just usually do not put a high percent passage rate judge in a chief ALJ position. You'll usually get either mid-low or low, but not ultra low. Like they won't be the extreme that are put in the chief ALJ position. It'll be usually mid-low or low. All right, next one. With that said, we've gone through a lot of things that potentially could mean that you would get a denial. And I want you to understand these things because, a lot of people are like, hey, what's that mean? Or what's this thing? Or how does that work? I didn't really so much go through what all these are and in detail about it, but I wanted you to understand the general items that could potentially occur post-hearing when you're waiting for a decision for your Social Security disability claim, and that they probably might mean there's something negative going on. Doesn't always mean that. A lot of potential, but it usually does mean that. Anyways, it is 1:53 a.m. I have to wake up tomorrow morning. I will catch you a little bit later. You have a wonderful, wonderful night. And remember, tomorrow, Tuesday, on Facebook, we will be live answering questions for those who call in, usually around 8 or 9 p.m.-ish. All you've got to do is call the 407-279-1754 phone number. It's the phone number that's on all of the stuff. And then you'll call in. You'll get me on the phone. Just remember, when I'm on the phone with somebody else, you can't call in. There's a couple of basic rules when you call in. Don't use your real name. You get about 5 to 7 minutes. Have your legal question ready. No story mode. Other than that, I will catch you tomorrow at the live session on Facebook, and then we'll probably also do some YouTube videos as well. Go sleep well, my fellow insomniacs. I'll catch you later, and thank you so much. All right. Bye-bye. Bye-bye.